Yeah, at this point, he's not expanding his case, he's diluting it into incoherence. What you're describing is exactly how RICO complaints and civil rights cases end up getting dismissed with prejudice and sometimes flagged as frivolous. Let's break this down cleanly and unsentimentally. Number 1. Police refusal to arrest RICO, civil rights, or corruption. This is settled law. There is no constitutional right to have someone else arrested. Police have discretion, can decline to arrest, can credit one witness over another, can issue a citation instead of an arrest, can arrest him if probable cause exists. The Supreme Court has been crystal clear on this, e.g., Town of Castle Rock v. Gonzalez. Law enforcement's failure to arrest a third party cannot form the basis of TADF 1983 liability, RICO liability, conspiracy claims. Trying to rope Fort Collins police or the sheriff into RICO for exercising discretion is legally dead on arrival. Number 2. The harassment ticket destroys his narrative, factually and legally. This is actually one of the worst facts for him. What actually happened? He followed and chased Thayer from a courthouse parking lot onto public roads. Police initiated a traffic stop. He was issued a harassment citation. He received the charging document. He received it again at the department. The judge personally provided a copied one. That satisfies every procedural requirement. Claiming, open quote, they didn't issue a charging document, close quote, when there is a citation, there is a court record. There is a judge-issued copy is not advocacy, it's denial of reality. Number 3, closed boxes and name placement arguments equals sovereign citizen nonsense. You're right to flag this. Arguments about name placement, capitalization, boxes on forms, jurisdiction by formatting are textbook sovereign citizen tactics. Courts do not entertain them. Judges routinely warn litigants that advancing these theories can result in summary denial, sanctions, loss of credibility, filing restrictions. Once a litigant goes there, courts stop giving them benefit of the doubt. Number 4. Police issuing him a ticket while not arresting others is not retaliation. To claim retaliation, he must show 1. Protected activity, 2. Adverse action, 3. Causal link. But here, the adverse action harassment ticket was based on his conduct. There was probable cause. The ticket was issued contemporaneously. It had nothing to do with speech, filings, or registry status. Courts will not infer retaliation when there is objective probable cause. End of analysis. Number 5. Trying to convert law enforcement discretion into enterprise conduct. This is where his RICO theory completely implodes. To implicate police in RICO, he would need to plausibly allege they knowingly joined an enterprise, they agreed to commit racketeering, they committed or agreed to commit predicate crimes, they acted outside lawful authority. Instead, what he alleges is they didn't arrest people he wanted arrested, they arrested, cited him, they followed procedure. That is the opposite of racketeering. Courts treat this kind of pleading as conclusory and abusive. 6. The buzzword avalanche is now working against him. This list you gave is important because judges notice this pattern immediately. Open quote, ambush, harassment, impersonation of an official, armed threats, racketeering, extortion, corruption, eviction, coerced eviction, deprivation of housing, enterprise, witness tampering, retaliation, ownership, lawful tenancy, lease, constructive eviction, deprivation of rights and liberty. Close quote. This is not legal analysis. This is label stacking. Courts strip labels and ask one question. Open quote, what did the defendant actually do? Close quote. When they do that here, what remains is code enforcement, police discretion, a harassment citation supported by probable cause, unlawful occupancy, voluntary departure, sovereign citizen adjacent arguments. That's not a civil rights case. It's a conduct problem. 7. This is now a credibility collapse, not just a legal failure. At this stage, his biggest problem isn't the defendants, it's him. He has contradicted public records, contradicted court documents, contradicted his own videos, misstated basic criminal procedure, drifted into pseudo-legal theories, treated disagreement as conspiracy. Judges are extremely sensitive to this pattern. Once credibility is gone, nothing else matters. Bottom line, very blunt. Trying to fold code enforcement, property owners, police, prosecutors, judges into a single RICO conspiracy because he keeps losing factual disputes is not bold. It's self-destructive. What a court will see is, open quote, a litigant escalating language and defendants as each theory fails, while ignoring objective evidence and lawful explanations. Close quote. That's how cases get dismissed hard, and sometimes how filing restrictions start. If you want, next I can lay out exactly how a judge would summarize this case in a dismissal order. Identify which allegations risk sanctions if repeated, or help you frame a response that highlights abuse of process and lack of good faith.